We are proceeding on well. The next question, what is the specific age of succession? I don't understand very well, but maybe we'll be able to interpret this question nicely. What is the specific age? Is it for somebody who is going to, for somebody to succeed a property or an estate? Maybe that's the question. How old should they be? Like if a property or an estate was left, what age is allowed by law that I can now I can come and succeed the person who left the land? I think that's what the question. Or maybe if you're here and you know that was your question, you can clarify.
If okay, I think I understand, because it cannot be what age must you die for your property to so I think you see, for property to be registered under your name, you must, for land to be registered under your name, you must be 18 years and above because of documentation. So everybody is entitled to succeed, even the ones that are underage. But now the property will be in the name of the administrator in trust for the children. When they get to the age of majority, which is 18, then the property is transferred to them. So it will be written in the name, but in trust. In the name of the administrator, but in trust for the children. Yes.
Thank you. I think that's a good answer. And now I know that all of us here are the majority. You must get the age of majority. So if you have 18 years, you are the majority. What if both partners are deceased? The next question. What if both partners are deceased? They didn't have kids? Who is supposed to succeed the estate? Both partners are dead. They didn't have kids. Who is supposed to succeed the estate?
It is parents. So it goes to the parents. If the parents are not there, the brothers are brothers and sisters. If they are not there, step brothers, step sisters. If they are not there, grandparents. If they are also not there, surrender to the estate.
Right. Something additional here?
If the title is in partnership, and Mzee thinks that he can go and write his own will somewhere with a Wakili, is that will valid? For instance, the title is with my name and my wife. Then I don't involve my wife when I'm going to write the will. And probably whatever that I'm going to say, I will give her a portion and the rest of the children. Is that will valid?
In as much as that property is concerned, you remember we said that will not be subjected to succession because you are jointly registered. So it will automatically go to your wife, whether you mentioned her, you didn't mention her. Yeah, 100%. Yes.
Thank you. And that's why it's good to write each other's names. If my mother, sorry, there's a question.
Thank you. So, Wakili, there's a concern. I don't know whether you heard of it. I've come a bit late about when someone dies, there is always this fight. Nani amemwona mara ya mwisho, and nani atapatiwa certificate ya kifo. Is it the death certificate? So the one who has remained with that one, nasemekanga ni yeye anakuwa kama the custodian. He's a main guy. He's a master now. Is that a really concern, or is it something people create? That's number one. The second question is about inheritance, whereby a family, okay, now let me go back to the Bible. If you succeed, if it's a father who has died, or both parents, like the story of Ruth and Naomi, the guy who was succeeding was to take care of even the children of the deceased, So if you inherit his property, you also inherit his responsibility. Is that applicable in Kenyan law, whereby if you inherit, you not only inherit the property, but also inherit the responsibility? That is, if there were liabilities, you're the one who is supposed to pay, or the guys who have succeeded, kama kulikuwa na loans, they also inherit those loans or anything. So those are the two questions I needed your clarification on. Thank you.
Court might assume, or we will assume, unless all of you are against it, that this person who has most of the documentation is most probably the best person to be the administrator. But again, all of you can say no. We are not comfortable to have him as the administrator, because an administration process, the court will try as much as possible to get the person who everybody is comfortable with. So, and there is no real advantage to an administrator, because they will do everything as per the directions of the court. And during the succession process, and after the succession process, he will transfer all the property to everybody who has been awarded under the succession proceedings. The other question, remember what we said is that you only succeed net estate of the estate of the deceased person. So all liabilities must be sorted before succession. But again, all those liabilities must be brought before the attention of the court before succession ends. So if the person dies and they owe you money, or there is a land they had not transferred to you and you had purchased, you have to cite court, so that court is aware of your liability, and so that you are sorted before the estate. But if succession is done and people have been given their properties, then it's the time you are coming with a liability, then you cannot be assisted by court. To be taken care of. Two things. We said that in a Christian marriage, the children don't succeed immediately. Property goes straight to the wife. Who? Watoto?
Si unajua sasa wanagana mali, wewe brother, wewe ni nini. You know, those kids maybe they be, what I'm looking at is that picture whereby they are not really part of that. You have written a will, but somehow you did not include the young people, all the responsibility this man had.
Which young people? Your children?
Your children, or something you are taking care of, even some children you had adopted or something like that.
No, those ones, if you remember, I said they will be called dependents. And the dependents are the ones who prove to court that they were depending. So they are the ones to come to court and prove that I was a dependent, depending on the deceased person. Then you will be sorted from the estate. But it is you to prove that you are a dependent. It's different from a beneficiary. I had made that clarity as we were beginning. So it's different from a beneficiary, because now those ones are not beneficiaries, they are dependents. And they are the ones to prove to court that they were depending.
Thank you, and I see our time is really moving fast. If you allow me, I would read the questions we have now. If my mother's husband is not my real father, and I don't stay with him, can I succeed his property? I think you've mentioned that somewhere. If the person proves dependency, right? Yeah, if you prove dependency, then you'll be considered. Thank you. I'll come closer to Wakili so that I can be putting these questions that we've already read to him. The next one, clarify. It has two portions of the question. The first part of the question, clarify under customary law the percentage of contribution. Clarify under the customary law the percentage of contribution. I'm not very clear about what exactly that means. But the second part of the question, are children dependents or beneficiaries? I think Wakili will clarify that one. Are children's dependents or beneficiaries?
Children are beneficiaries and they are also dependents. But now, what I mentioned about dependents is you have to be from the estate. You see, now the estate, then there is an instance where the estate may not be able to take care of all liabilities and also take care of all beneficiaries and all the dependents. So that's why it's very important, even if you are a child and a beneficiary, also to bring out the aspect that you are also a dependent. For instance, if you are depending from the estate for school fees, then in the process of succession, you can cite court for a temporary grant for your school fees to be paid. So in as much as in that instance you are a beneficiary, you are also a dependent. unlike another child whose school fees was not being paid by the deceased person. So there is you can, if you are depending on the deceased person, you can cite some more benefits from the estate, and it has to cater for you, even during the succession process.
Okay, thank you. The next question, this is about selling a property. When the whole family agree to sell a property, but one of the family refuse, what happens? When the whole family agree to sell a property, but one of the family, I think this meant one of the family members, refused, what happens?
Property is owned by the registered owner, and the only right that is added to property is matrimonial property rights. So the only person who can refuse for property to be sold is your spouse. If they refuse, and they can object to a sale of property because they have matrimonial property rights. But children have no right under the law to object to a sale of property. That land belongs to the parent, and the parent, they have all the legal rights to sell the property, whether they involve them or they don't involve them.
Right, and therefore if you go to court, you get clearance. The next question. I'm just reading in between what he said, right? What is the process of obtaining subtitles from the mother title? Can such land be sold? I guess the land that... Let me read again. What is the process of obtaining subtitles from the mother title? Can such land be sold?
Subdivision. I think that one is...
It's about subdivision. And then the question process about the land being sold, is it the subdivided land or the motherland? I think that one was also not very clear.
Let me answer it the way I understand. If you have a huge chunk of land and you want to subdivide, of course, there is a process to it. You will go get a relevant consent, get a surveyor who will do the subdivision process for you. I think if I want to understand this question correctly, there are instances where land is sold to individuals before the subdivision titles are out, and there are other instances where the subdivided titles are out, and then you transfer the titles to, I think that's where the person is coming from, if I understand it correctly. And for me, it is risky to purchase property that is within the subdivision process before it has come to the name of the person who was subdividing. For instance, if the land belongs to me, I should subdivide and have all the title deeds in my name, so that the green card can read my name as the first person who owned the title, then I transfer it to you. There are many instances where people subdivide property, then the title deeds come in the people who have purchased the property, and normally it's because of saving stamp duty. So they don't want to pay stamp duty, so they do that. It's a Kenyaji way of doing things, but it can bite back. If somebody came to invalidate those titles in court, then the paperwork is not straight, because you will be saying this land was subdivided into what portions, then the portions don't have the name of the person who had subdivided the property in the green card, so it becomes a risk. So if somebody is subdividing land then selling to you, insist that they first the titles come in their name, then they transfer to you.
Right.
I hope I understood the question well.
Hope so. Where I come from, they say Mogoda neke. Mogoda ne title. It means the land is the title.
Bwana Wakili, nilikuwa na swali kuhusu hiyo succession. Tuseme sasa ni mzee kwenye nimeolewa, like, baba wetu tupatie plot. Kuna hiyo case niko nayo na my cousin. Baba yao aliwapatia plot na akaandika kijana jina ya hiyo plot. Sasa huyu kijana yake akakufa. Mzee ako uhai. Kuna uwezekano venye huyu mzee anaweza rudisha hiyo title kwa jina yake ati kwa sababu kijana yake ameondoka na alikuwa na bibi.
That's not succession. Si bado wako alive. So that's a transfer. It's a transfer of property because the father is alive, if I understand the question. So, but it's not succession because haja kufa. No succession, lazima akufe.
So I think wanaelewa vizuri. Baba mwenye alikuwa ameandika kijana bado ako hai, lakini kijana mwenye aliandikwa ameaga. That ndio anasema si succession. Hiyo ni transfer. Transfer plot yake kwa kijana. Na kijana ako na bibi. Then huyu kijana ameaga. Inawezekana baba ajirudishie hiyo title iko yake.
Na ndio nasema mimi nimeelewa vizuri. The father transferring to the son is not succession. Because he's alive. So that was a transfer. So you cannot recall the transfer because it was not succession anyway. He transferred the property to the son. So the wife will succeed the son. Yes.
That's clear. Sio iko sawa? Inakaa kuna utata kidogo. Wacha.
Sasa sijui kama kuna sheria huwa inafuatwa, sababu sasa kama huyu my cousin venye huyo bwana yake alikufa, sijui kama huyu mzee alienda tena akabadilisha juu sasa vile kesi ilianza, mzee tena alikuja na title yenye sasa imeandikwa jina yake.
Hapo iko ukarabati na hapo niko kazi.
Sasa hapo utamuona hapo
Wakili, mimi swali langu ni hili. Huyo baba umepatia kijana yako title, amekufa na bibi yake ameolewa na mtu mwingine. Sasa utapatia mwanaume mwingine shamba lako kuprotect huyu kijana, kwa sababu mama ataendelea na maisha yake. Sasa mzee anaona mali yake inapotea.
What I said about in a monogamous marriage, the property kwenda directly to the other spouse, to the remaining spouse. If that spouse remarries, then succession must occur at that point, because now that spouse cannot continue to hold that property in trust for the children. So succession at that point must happen. If you remember what we said, in a Christian marriage, if one spouse passes on, the net estate will be held by the remaining spouse. So there is no succession. But if that remaining spouse remarries, then they have to undertake succession. Yes, there has to be succession because they are supposed to hold the net estate as long as they are not married. Yes. So it also depends on whether they are children now, because if they are children and he has gone to remarry, then they will do succession, then watagawana hiyo shamba. But the father cannot come and claim the property. I think the only instance where maybe that can happen is if the son had not transferred the property to his name. I don't know, I'm not sure. I'm only guessing. Maybe alikuwa na completion documents and hakuwa but alikuwa amesha transfer. Unajua unaweza pewa title ukae nayo kwa nyumba bila. Nilikuwa imeandikwa kijana. Then I don't know how hiyo alifanya ukarabati kidogo.
I think in that case hapa unaona wakili kwa ofisi yake, but in case you have such detailed that you need help, because sasa inahitaji solution, he can really help you. Atakupea address penye unaweza kumpata na pia contacts. And thank you for those questions that are coming through. Now, allow us to tumeshapita wakati wenye nilikuwa na promise by 10 minutes. Can I take 10 more minutes we finish this? Itakuwa sawa? By 5 minutes past 4 tutakuwa tumemaliza. The next question, wakili. In case of a will from the deceased husband and wife is not included. Let me come up again. Imeanza na kusema case of a will from the deceased husband and wife is not included and are in customary marriage. Is a case of a will, the husband is deceased and the wife was not included in the will and their marriage was customary. What happens there?
As long as the will is valid, you cannot invalidate it.
Can it be valid when the wife is not included in the will?
Yes, it can be, because any testator can leave out anybody. You know, you don't know the issues they had. can leave out anybody from the will. The only thing that person can do is to go to court for reasonable provision from the estate. But as long as the will is valid, that is not a material issue that can discuss the will. Because when you're writing the will, you never know. Maybe he even thought the wife wanted to kill him. So he left her out. You never know the issues they had. So he has a right to do that.
All right, thank you, Wakili. The next one, as a married daughter, can I go back to my father to claim inheritance? Yet I have brothers, and my husband has not cleared my dowry. Nirudie tena. As a married daughter, can I go back to my father to claim inheritance? Yet I have brothers, and my husband has not cleared my dowry.
No, inheritance is not subject to whether the dowry has been paid or whether you have been married. Because as I said, now the law is very clear. It has been interpreted. There is no discrimination as to gender. So everybody inherits their parents. So whether daughter, son, you will inherit. Yes, so there is no discrimination to it.
Whether dowry paid or not.
Yes, whether dowry paid or not.
As long as you're a daughter there. Now this other one, which is the last one, let me come closer here. It's interesting because I don't understand it fully, but maybe you'll understand it. What happens in a case of demise, yet there was a company operating in a land where title is owned by one person? What happens in a case of demise, yet there was a company operating in a land where title is owned by one person? I did not understand that question. Maybe Wakili, you can try and figure out what exactly that question will be meaning. But I don't know the contention here. Whoever wrote this, you want to explain, please?
Sorry, maybe it was not clear. But the question was, you own an investment together, and it's lying on a land, but the title is owned by the other spouse, not jointly owned. Yet the investment is jointly owned. So what happens in case of...
It is an intestate succession. Because if it is...
Let me read the question now with that one.
Yes.
So with the understanding, I can read the question in a different way. What happens in case of demise? Now in this case, we're talking about the demise of the person whose land is written their name. Or the other one. The other one.
Name is on the title.
The one whose name is in the title. Okay. And they have been having a joint company running on that land with the person who has not been left alive. So what happens to that person?
Now, it depends. There are many circumstances.
The question is about how this land now will be, succession will happen on the land.
So the title is in the name of the company?
The title is in the name of one of the directors of the company.
One of the directors of the company.
Yes, and the company has many directors. And that one person whose land, whose title is written their name, passes on. But the company is still on that land. So the question is about the succession of the land now or the company continuing?
Having the company there, or they can be because
Rejected.
of any other person pengine who has interest in that land can chase them out.
It's a complicated story.
You see, now, if I am a director in a company and part of my contribution is the land, see now, there is an aspect of company law there. Because see, a company is run through contribution. I can contribute. Oh, inasikika. I can contribute to the company, to the capital of the company by way of liquid, or I can by way of through the land. So it depends on whether it was capital contribution. And if it was capital contribution, then there is a bit of carelessness there, because the company ought to have now, the land ought to now be registered in the name of the company, so that now it's termed as contribution. If that is not the case, then it will mean property will be ceded and the flow of succession will come into play as I listed. So of course the beneficiaries will benefit The only thing the company can do or the other directors can do is to say that they are also beneficiaries to the estate of, and they were depending on the estate through that property, and there can be an arrangement to it, because if they have contributed to how the development are, so those can be valued. Now those are issues or semantics that you can take out in that matter particularly, but in a nutshell, the property will be succeeded under the law of succession. No, the company can only come in to say they are dependent depending on the deceased person's property, and they have to prove their case. Yes. Yes, because normally if it is a contribution, then a good company should have that property registered in its name, so that now it's a contribution by one of the directors towards the capital that company, because land is part of capital. So if they are investing on somebody else's property, unless they do a long lease, which if they do a long-term lease, there are long-term leases that even if there will be succession, and the long-term lease has been registered at the land's registry as a long-term lease, you cannot invalidate it because this person has died, because there are long-term investments already done on it. So if you had registered a long-term lease, then it changes the ball game altogether. But now if you're just investing, there is carelessness into it. Yes.
Wow, thank you so much. And I know our time is much spent. Wakili, do you mind? Nataka kukatizia hapo. Lakini sasa juu ni wachungaji, wacha niwape nafasi. Hawa wawili peke yao.
Wakili, tuambie kama umekalia, for instance, I have bought a land and I've given somebody akae hapo akitafuta mali yake na akae kwa muda mrefu. Is there any way ya kwamba anaweza sema hiyo shamba ni yake kwa sababu anakalia hapo? Ama kuna miaka ambayo you can say that this person has been there for about 40 years, so it's like the owner of the land.
So if you can, okay, that's adverse possession. That's adverse possession. If you are asking whether that person can go and claim adverse possession on the property, for adverse possession, you have to demonstrate that you are not permitted entry into the land. So if the person is claiming adverse possession against your property, then you also have to now come in and prove that you are the one who permitted the person into the property. As long as you permitted the person into the property, they cannot adversely possess the property. The time they adversely possess the property is they have been living on that land for that long duration of time, which is over 12 years. They know the land does not belong to them. They know the owner, who the owner is, because you have to adversely possess somebody, but that person has never interfered with their presence there. But if you are the one who allowed them there, then they cannot adversely possess you. Yes.
Then it means that he is entitled.
They can, but you see, for you to
If
adversely
I've not
possess,
given them permission,
yes, you have
and
not
they have
given them
invaded
permission.
my place.
They have been there. They know the property does not belong to them, belongs to you. But they have been there. You have not disturbed their presence there for over 12 years. They can go to court and seek adverse possession.
Kama shamba yako inalala mahali kuna mtu na muongeleshangi, anza kufikiria.
Thank you, Wakili. So my question is on the will. The will. If a family, they don't have a will, nor is there somebody who gives them a direction on how to succeed, but they sit among themselves, hapo wajigawanishe, you know, that kind of we chukua hii, chukua ng'ombe, chukua buzi. Would you advise that family to come back and go to court and seal that kind of your arrangement umefanya wakiwa familia? Would you advise them, or is that okay? That's number one. Number two is the format of a will. maybe majority of us don't have a will. Maybe you can give us the format of a will na utuambia ma unaandikanga will wewe sasa ukiwa wakili. Wewe unaandikagia watu will, unaambia mtu kuja nikuandikie will, unawekagia watu ili usaidie wengine wale hawana will hapa. Asante.
I'm saying just word on what Pastor Evans has said. It's good to know, because sometimes when you hear a big word, a big term, will, some of us, we say that is touch not, because you even don't know how much you. So maybe you can probably tell us how much probably it will cost somebody to draw a will. An ordinary will, not a very complicated will. A will of an ordinary human being.
The first question is, they have to go to court, of course, because now, as long as they have not undergone succession, the property remain in the name of the deceased person. There is no other way to have the property transferred to beneficiaries unless through a succession process. So in the long run, they have to go to court, undertake the succession, but that one will be easy because they have already agreed, and I'm hoping they have taken care of everyone. So if you have already taken care of everybody and all of you are in agreement, it's a very simple process. You'll go, it will be advertised, you go to court on that particular day. When you are summoned, you go and say you have agreed as per the petition, and the court will agree, will just grant. So it's not a very complicated process.
It is mandatory.
Yes, it is mandatory
for every person to have a will. That's what you're saying. Because
No,
even if you don't have a will, let me just try to put it. Even if you don't have a will, there are guys who will still come back and go to court and try to come up with a will, or kind of come up with a succession. So for me to help them, it's important for every person, or every man, or every woman, to have a will, so that you can help them. Because that's what I'm trying to. Because if you say that even if they have their eternal arrangement, they still come back to the court for succession. So it means that we must. That now takes me to the next question, which if you want to write a will, what happens?
Now, whether there is a will, or no will, you have to go to court. Hiyo kwanza tuelewane. If there is a will, you go to court so that will can be confirmed. So it's the same process. If there is no will, you still go to court. If you have agreed, then it's easier. It's advisable to have a will because it makes the process easy. You sort out any quarrels that might come after. You leave your people in a better way, because now you have planned beyond you are living. So it's good when the will is there. But if it is not there and you have agreed as to how the property will be divided, it's also good because it makes the work easy. The problem becomes where there are people objecting to how the arrangement has been done, because now then you have to argue in court and up to an agreement, up to when the court gives a verdict. As to the charges, it's not safe to give a blanket figure because iko mtu atakuja nimwangalie but it shouldn't be expensive. We have something called a remuneration order which guides us on how to charge. One, it's based on the asset-based value that the estate has. Pia nitaangalia miaka yako nione hii will nitakaa nayo sana. So kama wewe sikai kukaa nayo miaka mingi, nitakulipisha pesa kidogo. But anyway, all notwithstanding, we have the remuneration order that guides on how we are supposed to charge, but it's a good conversation. Besides wills, we also have trusts that are also registered to do the same job. And actually, trusts are the best more than wills, because trust, you register it and you start implementing even at the time you are leaving. because a trust now is where the all your property is owned under the trust, and how that property is managed is by a trustee under the trust. So it gives it protects the property beyond you, because that trust will go beyond you. So trusts are the best, actually, beyond wills. So, but most people who do trust are the people who have a lot of wealth, and they want to protect it so that nobody mismanages the wealth after they are gone, and also they don't want to take a chance that they will write a will and people will start discrediting the will. So because a trust is registered, nobody can discredit it. Yes.
The last question was on what makes a will valid. I think the parts of the will or something like that.
The format.
Yeah, format of a will, or what makes a will valid.
Sasa hiyo ni siri ya kazi.
Siri ya kazi.
Lazima akuje kwa ofisi tumwandikie will.
Thank you, Wakili. I have a question here. I have my dad and my elder dad who died many years ago. He had 3 wives, but before he died, he subdivided his land kwa wake watatu sasa. But the problem was, the first wife had almost 12 children. The second wife had 7. The third wife, who was Gashungwa, came with 2 boys. But before my elder dad died, walizaa kasichana. Lakini wakati baba alipoaga, alisubdivide shamba yake na wake watatu. So wakawa na equal pieces. Now, problem mahali ambapo iliingilia ni kwamba wale vijana wa kwanza, ama yule mama wa kwanza, alikuwa na vijana wengi. Huyu wa mwisho ambaye nikachungua amekuja na vijana wawili ambaye hawakuwa biologic, hawakuwa wa the elder dad. Msichana ndiye tu alikuwa wa dad. So vijana walipoenda kotini, bado kesi iko kotini hata wa leo. Nilikuwa nataka uelezee kidogo juu sasa shamba bado wa mama wako, na yule mama ambaye aliwachwa na kasichana kamoja alipata bwana mwingine, na bado amekatalia kwa shamba ya mzee. Na vijana hawa wengine wanaleta shida, wale ambao walikuwa wamezaliwa na baba. Juu mke wa kwanza alikuwa na vijana wa 8 na wasichana 4. Those were 12. So vijana ndio huaga wanaleta shida juu ya huyu mama mdogo ambaye ni Gashungwa, na alikuwa amekuja na vijana wawili ambaye waligawa baba na hawakuwa wao. Tafadhali elezea.
That's a very long question. Siwezi weza kujibu lote, but first of all, begin by saying wale ambao walikuja na the last wife au vijana wawili, those ones, unless they prove dependency, are not beneficiaries. So those ones, they have to prove that they dependent on the deceased person. That's why I'm saying they have to prove dependency. It is them to prove. It is them to prove dependency. No. It's not automatic. No. You have to prove. So watoto wako. So they have to prove dependency for them because they will also succeed from their father. Yes. So that is number 1. Number 2 also, how the property is subdivided is not each wife equal share. It depends on the number of units. So the court will look at even consider the number of children. Each children is a unit, each wife is a unit. So the wife with more children, because it's not the wife who will get the property, it's the child straight from the beneficiary. So it's not that because he had 3 wives that every wife will get an acre of land from 3 acres. So the court will look at the number of units in totality. and then divide amongst them. So that's, I think generally that's how I can respond to it, but sasa tunaweza kaa chini, then I can advise further.
Sasa mimi ni mmoja nimewahi saidika nikiwa nimeenda kwa ofisi ya wakili huko bypass. Nilisaidika in one or the other, na hapo palikuwa ni my brother akona title deed, bibi akaenda akaweka caution kwa Ministry of Flood. Sasa my brother hawezi chukua loan, hawezi uza juu hiyo kitu inaitwa caution. Sijasikia kitajwa tangu niingia hapa. Finally sasa bibi wameshaashana for real, wameshaashana. Sasa nimesikia umeongea kuhusu trusted you whatever, wanaweza zuia caution isiwekwe? Iko
wakili atuambie caution inatolewa wangu aje.
Ni kutoa tu caution.
So amesema, umeelewa kesi yake?
Sijaelewa.
Ameelezea kuna ndugu yake. Ameelezea kuna ndugu yake ambaye bibi yake aliweka caution kwa land yake. Hawezi uza, hawezi chukua loan nayo. Naso ameachana na hiyo bibi completely. Lakini shamba bado iko na caution. Sasa anauliza kama hiyo trustee inaweza toa. Hivyo nimesema. Wame divorce na hiyo shamba imeandikwa jina ya nani? Ya brother. Jina imeandikwa shamba ya tatu ni ya nani? Ni ya baba. Kwa hivyo hata si ya ndugu yako. Your brother. Kwa hivyo shamba ni ya brother yake. Na wame divorce, lakini caution iliwekwa na the wife.
They had a marriage certificate. So they separated. Because we have to petition the registrar for the removal of the caution. So we can, if the registrar is not willing, because the registrar has the discretion to, based on the issues that you raise with him. If they don't, then you move to court. Uambie court pay an order so for that caution to be removed. So you can petition the registrar directly. If the registrar is not willing, you go through court for the caution to be removed. Yes.
Bwana wakili, sasa kuna hii issue ya kama kwetu sasa. Mzee alikufa. Vile aliacha amegawa shamba, aligawa tu si ati aliwapea title, so aligawa kienyeji, akaambia huyu hapo ni kwako, hapo ni kwako, hapo ni kwako. Sasa kuna shamba ingine my sister alikuwa analima. Na yeye sasa anasemanga ati mzee alimpea hiyo shamba. Vile alikufa ati sasa ni yake. So unaona hakuna mtu ako na title ati kusema nilipewa hapa. So hata yeye anasemanga pia alipewa. So hiyo shamba inaweza kuwa yake.
No, that one, the same thing we said. You have to undergo the succession process. Ya sasa property yote. Because you see, hiyo inamaanisha hakukuwa na will. Unajua hiyo kuambia mtu wewe lima hapa, that is not succession. Because if there was a will that was written, that is different from kuambia watu wewe lima hapa. Because as we said, a beneficiary should not know what is contained in a will. So hapo, already it's an intestate succession. So the best thing to do is muende succession, mpeleke hizo property zote, whether kuna mtu analima ama hakuna mtu analima, then court wapatie grant fairly. Yes, amongst everyone.
Now, I'm standing. But there's one that has come up that is, hiyo siwezi nikaisema kwa mdomo. Si ajiseme tu, atulizie swali.
So Wakili was just asking, are wives empowered to do a will? And can I do a will and maybe exclude my husband?
I think it's a valid one because there's a valid one, Rev, kwa sababu palikuwa na case where a man can write and na akose kuweka the wife kwa sababu ya sababu zake. So maybe that one is also a valid one. Let's hear from the law.
Sasa I inherit kwa sababu tumesema in the Kenyan law today daughters and sons can inherit. So it means that this man who has married this lady can also now start inheriting kule alioana na hajatoa dawari. Sasa aanze kuinherit vitu za zaware na hata kupeleka hata mali. So that's something that you need to really come up as a Pastor Mary. Lakini I know she has written me in her will.
If you know, then it's an invalid will. So yes, even wives can do wills. Anybody can do a will, depending on the properties that you have. Because if you have properties, also you need to manage them, so that if in case of anything, there is proper succession. So even wives can do wills, and yes, it can be a valid will if you exclude the husband. Of course, you are the one who knows why you are excluding the husband. The only thing the husband can do again, as I said, is to go to court for reasonable provision from the estate, or prove dependency. Now, dependency is different from succession. If you can prove you are depending on your wife, then you can be given reasonable provision for your dependency. For your dependency, yes. Now that's different from benefiting. You see, because the wife is the one who is entitled to inherit her parent, she is the one who inherits. But if the wife passes on and you remain and you are her husband, you can inherit on her behalf. Yes, because she is entitled. So you are one. You are one unit. So you can. But if she's alive, she's the one who will be benefit her parents. Yes, sure.
Interesting. I know this topic can't end now, and I know our time is much spent. Si tumalizie hapo. Reverend, naona venye unaniangalia. Tumalizie hapo. Wangapi wamebakisha na maswali? Tujue kama tutaita wakili another session. So maswali ni matatu peke yao. Maswali ni matatu peke yao. So can you kindly come hapa when uko na maswali? Ndio to avoid any other question coming up. Na kama utakuja hapa tafadhali usiongee after wao wakiuliza maswali.
Yagu is simple as this. Like now my daughter is married. Lazima nimugawie vitu yangu. That is something. Then if it is a lazima, hiyo vitu yangu itaandikwa yeye ama mume wake. Yeye. It doesn't mean whether she is in the will or is not in the will.
No, you see, now if you are writing a will, you are the one who knows whether you will include her or not. But if there is no will, she will succeed, and it is her will who will succeed. So she can transfer the property to the husband after she has succeeded, if she wants. Yes.
I want to ask a question. Assume a lady has been married with children and property. Then, Kube, the man had other intentions, getting the property. Who has more light? Is it the husband who was just married or the children?
And in this case, you're talking about the husband who has found the children with the mother already.
The mother and the
So these children are not his children. Okay.
So
the property is not his.
And the property, amepata property na akapata watoto na akapata.
Then bibi amekufa.
Alafu bibi amekufa. So let me help him get to the point with this what is happening. So there's a najua metajataja mtu na mconfuse kidogo. There's this singer naitwa Betty Bayo. She was married to Kanyari and they have 2 kids. And then now they separated. And Betty Bayo got married to another man who found her with the 2 children from Kanyari. And then Betty Bayo dies. So the man is left as the foster father to these children. And now the question from Margaret is, who is more entitled to this property? The children or this father, foster father? Oh, even Kanyari is in the picture? No, it's only those 2. According to her question, it's only those 2. Children ama their foster father? The husband now.
So the husband?
The original husband It's Kanyari who is a pastor.
Kanyari.
He's not in the picture
He's
now.
not in the picture.
Because he left. And now the kids are left with the mother. And then the mother gets married to another man. Whom they don't get a child with. And then the mother dies. No, the lady dies. So these kids from that other father are left with this foster father. And there's a property to be owned. So I think that's the scenario that Margaret is asking. So who is more entitled, the children or this foster father, to the properties? And I hope you're also asking this in relation to our situations. We are not asking for that case because a case in court, we cannot discuss it. So we're only discussing our scenarios. That was just an example.
You see, okay, there are very many issues that happen in a case because courts have inherent power to offer discretion to ensure justice. So there are instances where, of course, if you can be able to prove that the intention was the property, then it can be taken to but you have to prove beyond reasonable doubt that that was the intention. But if that one is not proved, then the succession process will proceed as normal. So the husband is entitled to inherit from the wife because the wife has died, so the husband will inherit because that's normal in succession.
So there's some proving to be done in court. Thank you. So let's get the last one. I'll have to fungia hapo.
Thank you. I have two because I'm the last one. One is on behalf of my community, Veta. Happened to be in the constituency office when they were forming the Ruiro land office. And there is a serious issue with succession in regard to land sale around this area, where you may find land is sold, then in between the person that sold dies. Then maybe the transfer was not complete and even the mutation process was ongoing. Then you find that the dependents or the beneficiaries, people that now can benefit from the estate, and they know because most of this land is from Gatundu. And something happened, there's a confusion between two offices, a Nyakenywa office in Gatundu and a Nyakenywa office in Ruiro. So now something happens that the dependents claim the estate, and you see already there are people that have been undergoing through a process, and now when that process now goes to court, there is either it is stopped or maybe the said dependents or beneficiaries get access and by right is given to them. Now, what happens to the people that are already settled in this space and the process was ongoing? Can they also be enjoined in the succession as interested parties? That is question number one. Question number two, you say that if you had the consent of the writing of the will, then that will might not be valid. Now, in an event you are a father, like maybe Reverend Moses, and he calls his children, the 3 children, or 4, then he tells them that I'm giving you A, B, and C, and actually you write the will maybe together with him, then that will, maybe it's also registered. Does it still mean it is not valid? Because, and you see, you already know what has been written in the will, you as all the dependents. Is it still, does it meet the threshold of validity? Thank you.
Thank you.
First question. Now, every transaction depends on how it is handled. Because if you remember, one, we said during a subdivision process, you remember what I explained. You have to await the subdivision to happen, then the title is in the name of the person who is transferring to you, so that now that person can be able to hand you over completion documents. So in handing over completion documents, they will give you the title, their ID, PIN, and everything else. Now, that is one way, that is one bit of ensuring you are safe in a transaction. The other way is the mode of payment, because you also have to pay through a bank or something that you can prove you paid. And the other one is ensure you have a sale agreement. Now, if you have those documentation and the property had not been finally transferred to your name, it's very easy for you now to petition to court so that that is catered in as a liability to the estate. So that land will be transferred to you through an order of the court, because you can be able to prove your case. You had a sale agreement, you can demonstrate you paid maybe a deposit amount to the seller. There was an exchange of some documentation, so it's very easy for you to prove. The problem becomes where you have no way to also prove that there was a transaction between the two of you, or that you had even paid some deposit amount and things of the sort. Because if you are handling a cash maybe transaction, then you cannot prove that there was a transaction between you and the deceased. Then it becomes very difficult if the beneficiaries are objecting to you succeeding. So you have to remember at all times that you are the one who will come to prove to court that you had a right because you had a transaction with a deceased person. So you have to ensure your paperwork is correct. I'm actually handling such a matter where the beneficiaries are saying that my client was not being sold a property that he was purchasing, and it's some prime land somewhere. But at least as we have gone to court and we have been able to prove that there was a sale agreement, we had paid some deposit amount, the surveyor, it is us who had paid during the subdivision process and things of the sort. So we are able to prove our case. Then it's a liability to the estate. The property is transferred to you. The other thing, as to the validity of the will, it is simple. As long as the beneficiaries knows the content of the will, it is an invalid will. The only thing, it will be taken as an intestate succession, but at least because you are in agreement, assumably, it will be easy. You'll just go and say, this is how we agree to the division of the property, as at how the father had told you, if you are agreeing. But if any one of you is objecting, again, it will go through the intestate succession process wholesomely. But that will is invalid. Yes.
Wow, thank you so much. Thank you Wakili, tupatie address ya ofisi na tupatie namba. Alafu ndio uketi. Ashikiliani kidogo, tutampigia makofi mzuri. Tupatie ofisi penye iko na namba. Watu wakupate hapo kama wako na zaidi ya hayo. Sawa.
Good. My office inakuanga pale bypass Kamakis. Hiyo building inaitwa Premier North Park, the one that has Naivas. If you come there, third floor, utanipata. My number is 0722 746 293. 0722 746 293.
Sasa sugua mikono vizuri, tumpigie makofi. He's done us a wonderful job, and without charging us. You know these things you normally hear about them when you go to look for somebody who is going to consult. So sugua vizuri mkono, sugua vizuri mkono. Moja, mbili. Asante Wakili kwa kutuelimisha. Na nimeona uko na constitution. God bless you. Asante. God bless you very much. It was an interesting, but then he's carrying a constitution. I've seen it. So he was serious. He was referring to constitution here. So thank you so much for making time to come and be sharpened. I'm very sure when tumekuja hapa mambo tumefunzwa mambo mengi. Na watu ambao hatujajua tumejua mahali pa kuyapata. May the Lord help us that we not leave our property to the world. To the property to it, and the verse in ulisoma, the evil men leave their good men, good people leave their property, they leave inheritance to their children's children. But evil ones, their property will go to the righteous. So I really hope your property will not go to the righteous somewhere. You'll be that righteous one. To leave a good inheritance to your children, waachie peace, wabaki na amani. Si ni kweli?